Good afternoon to all of you. We have a packed program today, our first of the summer. We're delighted to be with you. If Kathy, you could go to the next slide, I'll walk everyone through what we intend to cover. From here in New York City, I'll be walking through a bit of what remains in terms of our legislative session in New York State that just closed. Roger Bearden is also with us to add his perspective. Then we'll move to Lisa Feldman. And I should note, by the way, Roger's sitting in our Buffalo office and is typically based in our Albany office. We're looking forward to hearing from Roger from the road. Lisa, who's in New York City, will be covering details of this new EEOC Know Your Rights poster. Jared Joyce will be back and will be covering regional technology hub programming that's just launching. Paul Bueller, also familiar to many of you out of our Albany office, will be addressing NLRB independent contractor testing standards. Nicole Macris, who's new to the program, will be looking at artificial intelligence, a topic that we've covered, but really from the perspective of professional pitfalls, thinking about the attorney perspective and how that relates to all of you in the audience. John Riley, also new to the program, based in Syracuse, an immigration attorney, will be looking at visas and the relationship of STEM applications to the visa process. And then I'll wrap things up. So with that, let me turn to the substance for the day. And as I noted, the legislature closed out its work in New York State just recently. There was a bit of an extension, as I discussed during our last time together 2 weeks ago. There were a few more bills that got passed. There was a package around LGBTQ plus rights that is delineated there on the slide that the governor signed into law over the weekend. Also, the governor signed a law concerning reproductive rights and the usage of telehealth a year after the Dobbs decision. That was intentionally timed as well. And I'd like to turn to Roger Bearden, who will provide a deeper dive on a staffing bill that has made its way through the legislature. Roger?
So much, Gabe. And folks who typically have been participant in the bond Tuesday will remember that there's been an executive order in place back since 2021, which was Executive Order number 4, extended 22 separate times by the governor to allow for certain healthcare professionals licensed in other states to practice in New York State. Well, that executive order has finally sunset as of June 22nd of this past week. And in place, a bill passed both houses of the legislature and was signed into law, timed to coincide with the expiration of that executive order. So that's Assembly Bill 6697-B. And what is notable about it is that the coverage of the bill, now law, is narrower than the executive order. So it applies only to nurses and physicians. The prior executive order applied to a broader range of healthcare professionals and included things like physician assistants, respiratory therapists, lab techs, radiology techs, and all of those authorities for out-of-state licensed professionals have now expired. With respect to nurses and physicians, the bill has some specific procedures. The State Department of Education, which is the licensure body for New York State, has published materials. What you need to know is that the eligible people are people who were using the flexibility of the executive order as of May 22nd, 2023. They're applying to be permanently licensed in New York. And that there must be an application process submitted to the Department of Education to take advantage of this temporary authorization within 30 days of the legislation, which was signed into law on June 22nd. And then the length of the temporary authorization is 180 days, which is supposed to be enough time for that permanent licensure to happen for the particular individual. So obviously, if you have any questions, you can feel free to address them towards whoever you deal with at Bond normally. And as I said, the Department of Education does have some materials for those who are looking to move forward to avail themselves of this new law.
Roger, that's great. Thank you for the update. And let me also remind the group that there'll be plenty of more bills that we expect will make their way to the governor's desk for consideration with the legislature closed up for the summer, as it were. Now the process begins of packaging those bills to the governor. What we've highlighted in brief here are those few bills that we thought were worthy of your attention that have actually been signed into law. So more to come is the point. Speaking of more, let's shift to another speaker, and let's hear from Lisa Feldman, who is with us from New York City and a regular on the program, ready to share information about the EEOC Know Your Rights poster, which has been rumored for a while and is finally here. Lisa, please, the floor is yours.
Thank you, Gabe. Next slide, please. So as Gabe mentioned, the EEOC has released a new Know Your Rights poster. It's effective today, so hot off the press, so to speak. It replaces the last poster update that we did in October. The reason for the update is that the Pregnant Workers Fairness Act goes into effect today as well, and the new poster reflects protections there. I'm going to just briefly cover the poster, but if you'd like more info on the PWFA, I've linked to our earlier webinar where my colleague Stephanie Fedorka covered it excellently. Next slide, please. So here's what some things I've noticed are new. Under employment practices that can be challenged as discriminatory for failure to provide reasonable accommodations, it now includes pregnancy, childbirth, or related medical condition. Also conduct that coerces, intimidates, threatens, or interferes with someone exercising their rights, or someone assisting or encouraging someone else to exercise their rights regarding disability discrimination or pregnancy accommodation. And under types of employment discrimination that are illegal, interference, coercion, or threats related to exercising rights regarding disability discrimination or pregnancy accommodation. Next slide, please. So just a quick reminder that this must be posted conspicuously. Electronic posting is encouraged as well, especially in today's reality of remote work. There is a monetary penalty, and the EEOC reminds us to post in compliance with the ADA so that the posting is accessible to everyone, and they have some ideas on their website to be able to be in compliance with that. And just a quick note that this is from the EEOC, which enforces federal law, but regarding these issues, there are also state and local laws to be mindful of as well. And back to you, Gabe. Thank you.
Lisa, thank you for that brief and informative update. And we want to make sure that all of you are always familiar with, just go to our website and look for the slides. If you need to go back and reference any of these materials, we'll also have a link to the poster embedded in Lisa's slides. So thank you again, Lisa, for taking this time. Let's move now to our next speaker, who's Jared Joyce, back with us out of our Syracuse office, and here to tell us about a $500 million program that is, I think, worth the time that we'll be taking for all of you to learn more about it. So, Jared, thank you for coming back on the program, and please keep us all apprised. The floor is yours.
Thanks, Gabe. So the Department of Commerce and the Economic Development Administration have launched the application process for the Regional Technology and Innovation Hubs, or Tech Hubs program. The Tech Hubs program is a regional competition that's aimed at strengthening U.S. economic and national security through the investment of more than $500 million in regions that possess the potential to become globally competitive in the technologies and industries of the future. The program is divided into two phases, with each phase subject to its own notice of funding opportunity and issuing different types of rewards. Next slide. If you go back one. So the first phase offers two types of awards, a strategy development grant and a tech hub designation. You can apply for either or both. Strategy development grants are intended to help regions prepare to apply for implementation grants under phase 2. And the tech hub designations are a program that designates successful applicants as tech hubs. Tech hubs do not receive any funding, but you have to be designated as a tech hub in order to be eligible for phase 2. And they're going to designate at least 20 tech hubs in phase 1. Next slide, please. Phase 2 will be covered in a subsequent notice. In phase 2, they're going to award implementation grants, which would be used to fund projects in certain tech hubs that were designated in phase 1. Next slide, please. Eligible applicants for the program must consist of members from an institution of higher education, a governmental entity, an industry group, an economic development organization, and a labor or workforce training organization. Eligible consortia may consist of other groups, but they're going to be evaluated on the quality of their partnerships, not the number of people in the consortia or consortium. Next slide, please. Additionally, each consortium must select and identify a core technology area within or at the intersection of one or more of the key technology focus areas. There are 10 key technology focus areas, which include things such as artificial intelligence, high performance computing and semiconductors, quantum information science and technology, robotics, disaster prevention. Next slide, please. Advanced communications technology, biotech and medical technology, data storage and management, advanced energy and industrial efficiency technologies, and advanced materials science. So that's just a brief overview. We do have a more in-depth informational memo available on the website, and you can also feel free to reach out to me if you have any questions. Back to you, Gabe.
Fantastic. And really appreciate the updates on this and other technology funding that you've brought forward to this group, and glad that you'll be on the program again, I'm confident, with similar information. But let's move to our next speaker. In the interest of time, we have Paul Bueller back with us out of our Albany office. Paul has been on the program many times over and is here today to discuss the NLRB and its new independent contractor test. Paul, thank you for taking the time, and I look forward to learning along with those otherwise listening in here. Thanks.
Thanks, Gabe, and thanks everybody for tuning in. If we could just flip to the next slide here. So first, I just want to kind of briefly go over what is the importance of this test. So, you know, we're all familiar, or we should be familiar with the National Labor Relations Act. This is going to apply to all non-supervisory employees. It gives them certain rights, you know, things like to engage in concerted activity, to unionize, all those sorts of things. So because the act only applies to employees and specifically non-supervisory employees, it's not going to apply to independent contractors. And that means practically it's important for us to determine, you know, is somebody an employee? Do they have these protections? Do they have the ability to unionize? And you've obviously seen over the last few months a number of really important NLRB decisions related to things like confidentiality. You know, the NLRB's decision, opinion on things like non-compete agreements and those sorts of things. So again, how we classify individuals, whether they're an employee or whether they're an independent contractor, is going to be really important in determining, you know, do these rights and protections attach to this specific individual, right? So with that said, NLRB recently issued a decision about 2 weeks ago, basically explaining how to determine whether or not somebody is an employee or an independent contractor. Now, to kind of understand this test, we have to take a step back, looking all the way back to a Supreme Court decision from the 1960s. And basically in that Supreme Court decision, the Supreme Court outlined a non-exhaustive list of 10 factors that they considered to be important in determining whether somebody is, again, an employee or an independent contractor for purposes of the National Labor Relations Act. So that's what we've got on the screen here, these first 10 factors. As you'll note, these really hinge on how much control does the entity, the company, exert over that individual. So, you know, are they outlining their day-to-day job duties? Is this an individual who has a separate business and can deal with others and also work for this entity? Is this a very highly specialized skill, or is it, you know, more menial labor? You know, all those sorts of things. Do they bring their own supplies? Do they purchase their own tools as opposed to being provided those things? Is this a long-term or a short-term arrangement? All of these things kind of hinge on how much control does the company exert over this individual. The more control, the more likely they are to be considered an employee. The less control, the more likely they are to be considered an independent contractor. over the years, the courts and the NLRB started to add additional factors, and one was called entrepreneurial opportunity. So basically, they were looking at, does this individual have the ability to profit or loss from this enterprise? Can they hire their own employees to work for them to perform this specific task or project? Do they have the ability to work for other companies in addition to working for this employer? And do they have any sort of proprietary interest in the work? Do they have some ownership over the tasks that they're performing? So again, over the years, where relevant, the courts and the NLRB started to consider that. And then in 2019, there was an important decision, Super Shuttle. And essentially, that decision said, entrepreneurial opportunity, it's not really a separate factor. It's more of a prism. It's how we're going to look at all these other 10 factors. So, the extent of control that an employer might have over an employee, in some ways, it's kind of the opposite side of the same coin, control and opportunity to profit or loss. The more control that an employer, exerts over an individual, the less opportunity they have to profit or loss. And under the Super Shuttle decision, basically, they said, let's look at all of these 10 factors, but this kind of super factor that we're going to look at every single one of these through this prism, through this lens, is the individual's opportunity to profit from, whatever this enterprise is, control their own expenses, control their own hours, control their own time, and, again, make or lose money based on, the work that they're performing. In June, earlier in June, this year, about 2 weeks ago, the NLRB said that's an incorrect interpretation. We shouldn't look at every single one of these factors through the prism of the opportunity to profit or loss. It's really a separate 11th factor. It's non-dispositive. We're only going to look at it where it's relevant. And really the important inquiry is, how much control does the employer exert over the individual? So we're kind of returning to this 10 factor list. We're not necessarily looking at entrepreneurial opportunity, the ability to profit or loss, unless it's directly relevant. And so this came before the NLRB in a decision called Atlantic Opera. And essentially there were a number of stylists. They, were makeup artists, hairstylists, they wig artists, and those sorts of things. These individuals worked at an opera house and were selected for certain productions. They were paid hourly, and directors of these productions would basically tell them, this is the type of makeup that we want, and they were getting into, incredible minutia, things like, this actor should be wearing the same color nail polish as another actor and all these sorts of things. And this group of individuals, these stylists, attempted to unionize. And the opera house basically said, no, they're short-term individuals. Yes, they take up residence in the opera house, but they bring their own tools, bring their own equipment, set up their own things, within certain parameters. They're allowed to, go about their job duties in the way that they would like to do. And the NLRB disagreed and said, these individuals, again, you're getting into the minutia of things like how they actually, style a wig, the color of the hair, whether somebody's wearing a wig versus having their hair styled, the color of nail polish that they're wearing. And by the way, they're being paid on an hourly basis. Yes, they have to go out and purchase their own supplies, but they have less control over, their ability to profit or loss. So the NLRB basically said, we're going to return to this old test. Entrepreneurial opportunity is a factor, but it's not the determinative factor. We're going to consider it in conjunction with all these others. And ultimately, they determined that these individuals were employees, again, based on the amount of control that the opera house exerted over these individuals. So again, kind of taking this all together, the important consideration is, how much control does an employer have over an individual? Again, it's going to hinge on not just the individual's ability to profit or loss, not just their entrepreneurial opportunity, but also, is this a specialized job function? Is this, what in the locality do people normally do? Do they have the ability to work for others? It's going to be all of these things taken together, always going to be a very fact-based inquiry, but there isn't this overriding factor that, just their ability to profit or loss is ultimately going to decide the outcome. So moving forward, because of this new test, it's very likely that more individuals are going to be considered employees for purposes of the NLRA. So this is just another thing to keep in mind, in addition to all the other independent contractor tests we have to keep track of under all the other relevant employment laws.
Paul, thank you. Really useful guidance. And, to your last point, all the things to keep track of. That's what you and the others among the labor law team at Bond are here to help with. And so, Paul, we're glad that you can share a sample of what it is that we can do as a firm in order to help keep you compliant and otherwise to give you guidance on some of the really subjective matter here. Let's move to our next speaker and shift topics a bit. What we're going to be talking about now is artificial intelligence. We've had a few presentations over the last 6 to 8 weeks or so on AI as it has become more prominent in the news. And while, like the rest of the country, let alone the rest of the world, we don't have it all solved, what we're wanting to do is keep all of you apprised about some of the implications and the things that we're learning as they apply to all of you. And Nicole Macris is here, an associate out of her Syracuse office, who's a litigator. And Nicole has put some time and attention into learning more about essentially what the implications are for attorneys who utilize AI in ways that may be deemed improper or sloppy, as it were. There's been some news about that recently. And so, Nicole, we're interested in hearing from you about that. And again, why this audience should be paying attention to this. We look forward to learning with you. Thank you.
Thanks, Gabe. Good afternoon. So, as is the case with many industries, the legal profession is sorting out the role of AI as that AI has in the industry. So today I will discuss some of the pitfalls, as Gabe said, of the use of AI in the legal profession. The first is a recent case where an issue regarding AI arose, and that was in the Southern District of New York. It's titled Roberto Mata v. Avianca, Inc. You might have seen that in the news. By way of background, an attorney commenced an action in Supreme Court, New York County, and the case was removed to the Southern District of New York, which is when a colleague of that attorney took over the matter. The defendant moved to dismiss the case, and the attorney who commenced the action, so the initial attorney, engaged with ChatGPT for legal research purposes to draft an opposition to the motion to dismiss. So the purported research resulted in the use of 10 cases that did not exist, that were ultimately submitted to the court. Defense counsel informs the court in its reply papers that they were unable to find these cases. So the court asked the plaintiff's counsel to submit copies of those cases. Plaintiff's counsel complied and submitted them. The court determined that the 10 cases did not exist. And the attorney who used the ChatGPT for the purported research explained to the court that he did so because he did not have access to federal case law, at least to the extent that he needed. And he believed that ChatGPT was effectively a more advanced search engine. So consequently, both of the plaintiff's attorneys in the law firm that they were associated with faced sanctions. We recently learned that the court imposed the following sanctions: a $5,000 penalty, which was jointly and severally imposed. They had to notify the plaintiff of the proceedings and order imposing the sanctions, and they had to notify the judges named in the fake cases of the proceedings and the order imposing sanctions, and also attach the fake opinion in which that judge was named. So the court explained in their order that the record, and this is a quote, the record would look quite different if the respondents had come clean about their actions. So the court determined that because the respondents had doubled down and submitted the fake cases instead of saying we can't find these either, they had acted in bad faith. by, quote, conscious avoidance and false and misleading statements to the court. So the court explained that these sanctions were imposed to deter further action in other cases where people would use ChatGPT and where they would submit cases that were fake or cite to cases that were fake. And the case was ultimately dismissed as the court granted the defendant's motion to dismiss. So there was also another case in Colorado Springs recently where an attorney used ChatGPT reportedly after testing its reliance to draft a motion. Seemingly, the ChatGPT produced fake cases, and the attorney admitted so when he realized it the day of his hearing. Ultimately, the court denied the motion, and it is not yet known whether this attorney faces any sanctions. So now courts are beginning to respond to these issues presented by the use of AI in the legal field by implementing rules specific to AI use. And this seems to, they read as if they are to prevent these situations from occurring. So some court of rules are concerned with ensuring accuracy and reliability of the case law used. And interestingly, Judge Baden in the United States Court of International Trade expressed concern for protecting confidentiality and propriety information. So I think where we're going with this is that we can expect more parameters and guidance as the use of AI becomes more relevant in the legal profession. And we will be able to figure out how to responsibly use AI in the profession. And that is the broad overview on how, at least in terms of litigation, the legal profession is grappling with the use of AI. This is clearly an ever-evolving topic, and I'm sure we'll update you when necessary. Thank you.
Nicole, thank you so much for coming on. And as you point out in your closing remarks, really as attorneys, we need to be thinking about what the implications are of these evolving tools and the dangers of misapplying them. At Bond, we approach that all very humbly and with an understanding that yes, these tools can enhance the various parameters of our work, but they need to be wielded in a way that ultimately leads to the best results for the clients like all of you whom we represent, and to do so in a way that is ultimately consistent with the court's expectations. So Nicole, thank you for coming on and highlighting some of that for us. And we look forward to having you on future broadcasts as well. With that, let us turn to our last scheduled speaker for the day, who is John Riley, and John is out of our Syracuse office as well. John's a senior counsel who focuses on immigration matters, and we've had the pleasure of hearing from a variety of attorneys focused on immigration in recent programs. And John is here to address a particular nexus, as it were, involving individuals with background and experience in STEM, the sciences and those other related disciplines that are in some industries particularly attractive. And so John approached me with an interest in bringing forward to this program information about some loosening that he's seeing in terms of standards around advanced STEM applicants as it relates to visa provisions. So John, I look forward to learning more with the audience, and otherwise, please do know that we're always delighted to have you back on the program and glad that you're with us for your initial opportunity to meet this audience. John, the floor is yours.
Thank you for the kind introduction. If we could move forward in the slides a little bit. I'm basically here to talk about a recent policy that the Biden administration and DHS have announced and implemented, which essentially loosens the standard, or we believe loosens the standard for foreign nationals who are applying for permanent residence in the case that they have an advanced STEM degree, a master's or above. PhDs are particularly wanted, but we've been seeing a lot of approvals recently for master's candidates, even employees on OPT or STEM OPT, or who don't have significant work experience. So I would like just to give a little bit of a brief background on what the options are for companies that have foreign national employees if and when they want to sponsor these employees for permanent residence. So it really depends on, when I get a resume from a client, I'm really looking at the qualifications and the experience of the employee primarily, their experience with the particular company, and what kind of work they're going to be performing. So essentially, immigration law breaks down foreign national employees into two categories: priority workers and non-priority workers. Priority workers are, people with exceptional credentials, Nobel Prize winners, major prize winners, scholars with thousands of citations, people with multiple patents. These would fit into the first category of priority workers, called EB1A, extraordinary ability priority workers. These are very difficult to obtain, and we usually don't recommend these unless it's very clear that the employee has exceptional qualifications. If an employee is going to be working at a university or a research institute, or even a private company that employs 3 or more full-time researchers, like in a lab, we can apply for under the second category priority workers, called outstanding researcher or professor category, slightly lower than the EB1A standard, but the company does have to employ full-time researchers, and the employee has to be working as a full-time researcher in order to qualify. The last category, priority workers, is for employees who have worked overseas for a year for a related entity, whether it's an affiliate, a branch office, a subsidiary, and they're transferred to the U.S. for a temporary period of time in a managerial or specialist capacity. So this is actually very common and a very useful category, but it does require that 1 year of relationship of work experience overseas in order to qualify. Now, I say these are fast because all of these categories are eligible for premium processing, which means the government will decide the case within 15 to 45 days, which is like light speed for DHS. Cases that are not in premium processing can take a year or more, several years to approve. So that's one reason that these categories are very good. And because less people qualify for these categories, the visa numbers that are allotted each year for applicants from like India and China or other countries where the US gets a lot of applications, they have more visas available. So for example, if an Indian national qualified for an EB1, they might only have to wait 3 years for a green card. Whereas if they were in one of the lower categories, they might have to wait 13 years for a green card, depending on how many people are applying in a particular year. Go to the next slide, please. So those are the priority categories. The non-priority workers, these workers typically go through the PERM process, which basically requires approval of another agency, Department of Labor. So in order to qualify under this, you have to show that hiring this foreign national won't depress US wages. So you have to pay them a certain amount of money. And you have to show that US workers won't be displaced. So like, let's say a typical situation is you have an employee currently on an H-1B or OPT, and you want to hire them. You have to advertise that position, and you have to recruit US workers in order to fill that position. And if you cannot find a US worker, then you can offer the employment to the foreign national. So it's kind of it's kind of a backwards process, but the purpose is to protect the US labor market. So this is really common, again, for candidates, employees who are currently in the US employed under H-1B or OPT status. The downside is that the PERM process right now is taking between 18 to 24 months. So if you want to, sponsor an employee for permanent residence, you're looking at like a 2-year commitment in order to get approval from the DOL on the wage, and to get approval that you've done the recruitment steps right, and to get approval from DHS on the application itself. So they're just really, really backlogged right now. And another downside is if the employee ever changes positions, they have to refile the perm again. So if you get a perm approval, you go through this 2-year process, and then you promote the employee 3 years later, and let's say they're from India and they can't actually adjust their status for 10 years. You know, you kind of have to guess, like, what is this person going to be doing in 10 years? So it's a bit convoluted just because of the timing of how it works. And there are advertising and recruitment costs that are quite expensive as well. Have the next slide, please. So one option that we've been pursuing is kind of in between priority workers and non-priority worker perm applications. These are called national interest waivers. National interest waivers are completely discretionary, and basically you have to prove, and they're very subjective, that it's in the U.S. national interest to avoid the perm process and not advertise the position to U.S. workers and grant the green card directly to the immigrant. So you have to show that there's something pretty special about this person, that, you know, even if there are qualified U.S. workers, it's in the U.S. national interest, you know, to grant permanent residence without going through perm. So the major benefits of these kinds of petitions are there's no DOL involvement, so you don't have to go to the Department of Labor. And right now that's saving 18 to 24 months in processing time. You don't have to recruit the position, so there's no advertising costs in Sunday newspapers. HR managers don't have to interview applicants for the positions. National interest waivers now, and this is recent, as of this year, they are eligible for premium processing. So prior to this year, you know, it could take 12 to 18 months to process a national interest waiver. So we weren't as inclined to recommend them to clients because, you know, they were taking as long as perm applications. But now they're eligible for premium processing, which means once you submit the application, within 45 days, DHS has to issue either an approval or denial for the NIW, which is great. And they're doing it actually within 10 days typically, so it's quite fast. Another benefit is the national interest waiver is not tied to the job. So if you were to sponsor somebody for a national interest waiver petition, you wouldn't need to worry about promoting them later to a different position. Once national interest waiver is approved, that's basically permanent. You know, as soon as they're eligible timing wise to adjust status to permanent residence, they can use that approved I-140 NIW petition to do so. And once the I-140 is approved, it allows employees from countries that have these really extensive backlogs, particularly India and China, to keep extending their H-1B. So typically H-1Bs are limited to a 6-year period, but once you have an approved NIW I-140 petition, those H-1Bs are extendable indefinitely. Could I have the next slide, please? So because NIWs are discretionary, they're really subjective. And, you know, 20 to 30 years ago, the range of decisions, they were so inconsistent, and there were a lot of appeals. And, you know, the appeals agency, you know, tried to give guidance to officers, but basically it's kind of like luck of the draw of who you got as an officer. However, 2016 the standards were somewhat loosened, and then last year in 2022 the Biden administration announced this new policy for STEM graduates, and USIS implemented the policy in their manual. And basically, I put it in the PowerPoint here, but basically it says USIS recognizes the importance of individuals with advanced STEM degrees, especially if they are focusing critical and emerging technologies. So if we could go to the next slide, the White House publishes these lists of these kind of industries or technologies that they consider critical and emerging. So if you were to have an employee who had an advanced STEM degree, let's say a master's in engineering, and they worked in, you know, data analytics or AI, or I don't know, these categories are so broad. We can often fit employees into multiple categories. I don't want to say they rubber stamp these, but we've seen extremely quick approvals for even OPT students with like less than a year of experience. So we haven't done enough of these. We haven't done like thousands of these cases yet because they just implemented this policy, but we are starting to recommend to our clients to file NIW petitions where previously we would have recommended using the perm process. So I think I've gone over my time a little bit, but I'll leave it at there if anybody has any questions. Thank you.
Thank you, John. And really interesting and otherwise emerging subset of the immigration field. And it's important that our clients, particularly those who are looking to bring in talent from beyond the United States borders, are familiar with this. So please keep us apprised and please come back onto the program in the future. And so why don't we move, Kathy, to the next slide, please? I want to provide actually there's one that preceded, but if it's not one that you have in the deck, let me just share the information. It's a programming note. What we're going to be doing for the first time in a while is taking a pause on our programming. I know that Krista mentioned this last week, but a week from today is July 4th, and we recognize that all of you, by and large, will be off work and otherwise spending time away from your desks, and we respect that and hope that you honor that important time with family and loved ones. And so we also won't be going forward with our program next Tuesday. I will be back, though, on the 11th of July to resume our weekly cadence of programming. We're still developing that agenda, of course, but we look forward to bringing programming to you throughout the summer months and beyond. So if you do tune in next Tuesday, there won't be a program for you, but in 2 weeks' time, certainly there will be. If you do have questions or comments, by all means, reach out to any of the presenters. Their information is available right here for you on the slide. And as always, we know that your attention to what we share here on this program makes a difference, and your feedback as well. So if there are ways that we can make the programming even more valuable to you, please let us know that. We look forward to bringing you the kind of material that really makes a difference for all of you. And in the meanwhile, wishing you a really happy 4th, a terrific start to summer. Enjoy the grilling and whatever else it is that keeps you busy over these next few days. And we'll be back with you on July 11th. Have a good day.